Houston, Texas. Radio NMPC brings in immigration updates every Tuesday at 5 p.m. Central Time. Emily, what's going on? You know, there was an employer-employee relationship regulations. There was a court case. The court case ruled against it, and then they tried to reinstate it in the dying hours. And the Biden administration comes and stops it. Is that right?
Yes, that is right. But it was like Trump is haunting us from the grave or something, because the USCIS website today had updates about these new memos and policy guidance that was just rehashing what Trump had done 2 years ago. So the good news is those news releases were reduced, were eliminated off of the website, so it's nothing to worry about. It was just, seems to be a glitch where USCIS reposted some old news. But it is not real news, so don't worry about that. You saw today it was about the H-1B employer-employee relationship and the lottery system being reversed. All of that is old news. It happened already. It is not new news, and you can ignore that.
So in other words, we don't have the new employer-employee relationship. We are stuck. We're still with the IT serve litigation, what was settled between the USCIS and IT service, right, Emily?
Correct.
No new regulations, no new memorandums, nothing has been done. So we're in the old system. That's very good to hear. I mean, all of a sudden, you know, we got an impression saying that, ooh, what happened? Biden is turning to the evil side, and it seems that it's just a confusion. It's not the real thing what happened. So that's good. Now, Emily, on the H-1B lottery system right now, they said on March 9th we can start enrolling in ourselves. It was March 1st before, now it moved to March 9th. What about the salary level? Previous and last week we said we were in limbo in the salary levels. Which salary level? Is it based on the salary level right now, or is it just like the way what it was last year?
So this year's registration is going to be exactly like last year. No need to worry about the salary level. They don't even ask questions about the salary or the SOC code or the LCA details. None of that is required for this year's registration. It'll be exactly like last year.
So now, can you explain, if I'm, Emily, a person who has I'm in USA, I have a job now, how do I get into the lottery system?
Right, so you'll have to work with your employer. Your employer will typically work with an attorney to submit an electronic registration beginning on March 9th. There's a 2-week window where attorneys submit those on behalf of the employer. So from the employee side, what you need to be doing right now is coordinating with your employer to ensure that they will put your name in the lottery for this year, start gathering your documents, and get those submitted to your attorney who's handling, for your employer's attorney who's going to be handling that. So documents you'll want to gather for that are your education documents, so your degree certificate and your transcript, as well as your passport, biographic data page, the one with your picture on it, your visa stamp, your I-94 card, and any other status documentation such as I-20s if you're an F1 student, or your OPT card and things like that. All of that should be provided to the attorney's office as soon as possible so that they can start preparing to be able to submit those registrations March 9th. Now, the registration is done between the employer and the attorney, so you as the employee will not have access to any of that information through your My USCIS account. You'll have to wait until your employer or attorney notifies you whether you've been selected, which should happen around March 31st, the last day of the month, and then the filing window is expected to open April 1st.
That's very good to know. So it's much, you know, it seems to be the same as last year, just the dates have changed from March 1st to March 9th. Emily, we are having problems right now. There is a law that says that if the application is pending, we can start working. For example, when we file a H-1B transfer from company A to company B, we can start working as soon as, you know, application is pending. We have the same scenario when we file from OPT to STEM extension. When the application is pending, they can start working. When the AOS EAD extension is pending, they can start working. Now the problem is, what used to take a week or 2 weeks or 3 weeks at the most for getting receipt notices is taking 3 months. So I'm going to ask you, run through each scenario and ask, what if the receipt notices has been delayed? What is the solution for it? For example, if a person is filing an H-1B transfer application, H-1B extension application, or H-1B amendment application, either of those three things allows that once we file the application, they can start working with the respective company or respective job. Now, if the receipt notice has not been received for the H-1B, can they still work? Or do they have to stop working? In the extension case of the I-94 is valid, they can work. But if the I-94 expired, can they still work, or do they have to stop working?
Right, so you are authorized to work based on a pending extension, a pending transfer, a pending amendment. That's very clear in the law and regulation. So the issue is, how do you document that? And the reason the documentation is important is due to the I-9 requirement. So anytime an employer hires a new employee, they have to have you fill out the I-9 form that confirms that you are authorized to work and verifies your identity, and then you provide some documentation to your employer. They verify it, write it on your I-9 form, or fill it out electronically. That is a very important document that the employer must complete so that you can be employed. Now, what do you do when your receipt notice has not yet arrived? For the situation of an H-1B transfer, extension, or amendment, you should have, or your employer is the one likely who sponsored you, and so they know that it's been filed. So they have the copy of that I-129 form. They have the FedEx tracking number. They can put that information showing the confirmation that the FedEx, that the package has actually been delivered properly to USCIS. Provide that information as part of the I-9, and there's special provisions in the M274 handbook that explains what to do in that situation, what documents to provide, and how to complete the I-9 form. But basically, you use the tracking confirmation, you use the copy of the I-129 form, and you use your existing I-94. All of that combined shows that you're authorized to work. When that receipt notice comes in, you update it with the receipt number, and then when your approval notice comes in, the I-9 is updated one more time with the new expiration date.
So no danger even if they don't receive the receipt notice of this. Now, what about the scenario where a person is on OPT though, and they are applying for the STEM extension? The rule says that when the STEM extension has been applied, they can work up to a period of 180 days. Now, they didn't receive the receipt notice. What's the solution for it? They don't have the I-129 here. What do they have here?
Right, so in this situation, you do have your expiring EAD card, and you have your I-20 that authorized you to file that STEM extension. You have your I-765 form that you mailed, and you have the tracking confirmation. So kind of like the first example, but this time you use that I-20 from your school along with a copy of the I-765 form and the tracking information to document that it was actually filed even though the receipt is delayed. When the receipt comes in, you update the receipt number, and then when the approval comes in, you update the expiration date.
Wow, that's so good. Though, can I assume it's the same thing with the adjustment of status EAD extension, because the law says that if you file for an adjustment of status EAD extension, they can work up to a period of 180 days.
This is where it gets a little tricky, because the M274 handbook for employers for the I-9 that I mentioned earlier has those ideas spelled out for the H1 situation we talked about and the STEM extension situation we talked about, but it does not have the same language in the AOS EAD renewal. It says that you have to have the expired EAD card and the I-797 receipt notice. It does not specifically say that you can use the copy of the I-765 and the tracking information. So at that point, it's really going to be up to your employer and what their normal procedure is. Are they going to accept the documentation that you filed the application and allow you to continue working? Or are they going to be very strict on that and wait until you receive that receipt notice before you can work again? It is a gray area for employers. It does open them up to some potential risk and liability for I-9 non-compliance. So employers are going to take that very seriously, and it's something that they need to work through with their legal counsel.
Okay, Emily, one thing is right now a $1 million question to a lot of people is the maintenance of status if they are an H-1B and adjustment of status.
So what would you do if you are an H-1B worker, you've just filed your 485, you have your EAD now, you have your advanced parole, and your H-1B is due for renewal later this year? Would you ask your employer to renew it?
Personally, myself, if the I-140 is approved, Emily, and if I don't have any kids born outside this country who are teenagers, I am going to kick away H-1B off. I'm going to move on to the EAD. Now, people have heard a lot of times that, don't use the EAD. Yes, there are some limitations why I have told you that, especially if your I-140 is not approved. In October, we have emphasized very much on the dangers of marrying to the adjustment of status, what you need to be aware of. But at that point of time in October, remember, most of you guys were filing an I-140. If the I-140 is not approved, I would not use the EAD, Emily. But if the I-140 is approved, I'm going to use the adjustment of status. Now, can I flatly tell all the people that, hey, use the EADs? No, I won't tell them. I won't tell them. I'll give them options to do it. Why is the whole internet buzzing saying that don't use EAD, only use H-1B? One thing I believe in, a lot of lawyers make a lot of money when you maintain the H-1B and adjustment of status. That's one of the major incentive for the lawyers to tell you to maintain the I-140 and adjustment of status. Now, are there any rare scenarios where you could be in danger in using the EAD and letting the H-1B go? There are some rare scenarios, and if there is any criminal history, there are some rare scenarios where they have some very frequent travels that they need to do where the advance parole might get a little bit delayed. But most of the time, maintaining the H-1B has more dangers, according to me. Because when you file the H-1B extensions, there is always a chance of extension getting denied. How many times have you seen EAD extensions getting denied under adjustment of status? None, I haven't seen it. How many times have we seen H-1B extension denied? Speak about in 2017, 2018, when Trump was in full power and the courts didn't act by that time. Yeah, we used to get a denial every day, 10 of them actually. So it may have an impact when the H-1B gets denied. The adjustment of status law officer is looking into, an officer has denied that there is no actual specialty occupation position here. What do I do with this adjustment of status application? So that's one of the danger that maintaining the H-1B. There are some minus points in using the EAD, but in general, if I don't have any teenage kids and I-140 is approved, I will get married to the EAD application, Emily. Now, when I say using the EAD though, I would say that if I were to use the EAD for the existing company that filed the adjustment of status, I would do it right now. But if I were to use the EAD to join some other company though, I want everybody to be very careful that there is a 180-day rule that you must be working with the company that filed the adjustment of status if you're already working for the company. There's another video we have put in about 5 days ago. If you're contemplating of changing the job from company A to company B while the adjustment of status is pending, we want you to watch that video. That video is exclusively only on what to do if you want to change the status. If you want to change from company A to company Y while the adjustment of status is pending. What would you do, Emily?
Yeah, I think if my I-140 is approved and I don't have a child at risk of aging out, and I'm not in the strange situation where I got married after I filed the 485 and maybe my spouse hasn't been able to file yet. Other than those situations, I think I would choose the EAD. It's much easier to get that extended. You don't have to worry about end client letters and contracts and specialty occupation and H4 and EAD taking 2 years when you can get a simple 485 EAD automatic extension for 180 days just by filing the application. There are a lot of plus sides to just using the EAD.
And then don't forget that the minus side is that you pay a lot of legal fees for the H-1B. I'm not saying that lawyer won't charge for EAD extensions. That fees is way, way less than that of the H-1B. And what about the filing fees, Emily? How huge is the EAD extension filing fees?
Yeah, that's a great point. There's no filing fee at all.
No filing fee?
And for the H-1B, you know, if you want to file in premium processing to get a reasonable time, it's $2,500 plus $460 for the regular filing fee if this is your second extension or beyond, which many people are to that point. But yeah, the EAD
and then
certainly
the
looks
H4
good.
fees, H4 EAD fees, and the legal fees. This mounts a lot of money, pressure on the company, pressure on the individual. I would get married to the adjustment of status application. You know, that's the best thing that I would do. If you want to, there may be some peculiar scenarios where there may be some past violations, past things. You may want to consult with your lawyer to go through the entire file to see if you're okay to get married to the adjustment of status. By this time, most of our audiences are well aware of what a marriage to the adjustment of status application is. So if you're considering maintaining the H-1B also, it is worth for you to consult a lawyer to get an individual opinion. Is it worth to have so much expenditure for the company and for you, especially in the H4 plus EAD for your spouse? There's a lot of money involved in it. In this case, EAD is free, advanced parole is free, and no filing fees, and that's so good. So please consult either way if you are thinking this way or that way, because don't waste your money. And you know, there is a lot of incentive for lawyers to tell that, to maintain both, because remember, we make money when you maintain H-1B, lots of money. So please be careful on people advising you on leaning towards that. Let's go to questions.
All right, time for some questions. So Swati from Facebook wants to know, what's the current processing time for getting an EAD for an H4? So assuming it's a standalone EAD, it could take anywhere from 6 to 12 months. The service centers are not very fast right now. You can get those processing times by going to the USCIS website and clicking on case processing. You can select the service center that yours is pending at, and it will tell you specifically for an I-765 that's filed separately from the I-539 what those processing times are, but they're much longer than they've ever been.
A lot of people are speaking about the receipt notices of the adjustment of status applications filed. The applications that were received by October 30th of 2020, we have received the receipt notices for each and every case. For the cases that have received after October 30th, though, we have not received receipt notices for most of the cases, especially the ones that were filed in Texas address, which is Louisville, Texas address. A lot of people, when they panic, my case was been sent out on October 20. They say, oh, it's been sent out on 29th. It's been sent out on 29th. It's different. When it is received by the immigration, it's very important, though. There are some cases of October 30th that may not have received the receipt notices, but the checks have been cashed, Emily. All the checks by October 30th has been cashed right now. If you are filed by October 30th and the check has not been cashed, definitely there might be some problem with your case. You may want to speak with your lawyer on that.
All right, Manipal from YouTube wants to know if you can work 2 jobs while on OPT, one part-time and another full-time. This is specifically allowed if you are within your 12 months initial OPT time. When you get into the STEM extension, I wouldn't say it's prohibited completely, but there are some questions about how you can be properly trained and supervised and follow the training plan, the 983 training plan, with 2 different employers at the same time. So it may not be possible during the STEM extension, but no problem during the initial OPT.
Shanila Rubab has a question. Can I travel on H4 extension? My spouse H-1B is already approved. Yes, you can travel. If your visa is still valid, you can come back on that visa. If your visa is expired, you can use your husband's H-1B approval to get the H-4 visa extended. A lot of people are under the assumption that for H-4 visa to be stamped, you must have had the H-4 extension. That is not true. If you have your spouse's H-1B approval, you can use that to get the H-4 approval. That's how I came into United States 27 or 28 years ago on H4, I never had a H4 approval. I just used my wife's H-1B approval and showed the marriage certificate. That's how I came in. In the past 28 years, nothing has changed on that. You can use your spouse's H-1B approval and your marriage certificate and other documents like passport, and that's enough. You don't not need a H4 approval for you to get the stamping outside the country.
Venkata from YouTube wants to know if he travels to India while on the STEM extension, will those days count towards the 150 unemployment days? There is some potential for that to happen. So in your case, you mentioned you'll be working remotely during that time. So I would recommend when you're returning to the US that you have documentation with you that shows you were working that entire time, a letter of support from your employer confirming that this was a valid travel and that you are still considered an employee. Otherwise, yes, that could be considered unemployment time.
Questions are coming with regards to the consulate's office though. We have seen an increased appointments in the consulates all around the world, particularly in the US consulates in India are a little bit more open as compared to previously. They're not postponing the interviews, at least right now. We have been telling that they've been postponing, be very careful. But in the recent past, we have seen that no postponements of the appointments are there. So you can still go there and make the appointment and attend. Of course, this can change though. If it changes, we will inform you. Right now, they are not postponing the appointments. They are honoring the appointments.
Mukesh from Facebook has an I-140 approved in October of 2019 and wants to know if it's safe to change jobs without hurting that I-140. Well, you didn't mention that you filed an I-485, so that can cause some issues. If you've not yet filed the I-485 and you change jobs, even if it's more than 180 days after your I-140 has been approved, that I-140 doesn't move with you to the new employer. The new employer will need to file a new labor certification and new I-140 before your priority date is current so that you can eventually file the I-485 adjustment of status. But make sure that once the I-140 is approved, you should wait for 180 days before making any job change, because that will at least ensure that you can keep your priority date and your spouse can get an H4 EAD using that I-140 from the previous employer, and you can continue getting H1 extensions with that employer or any new employer once you've waited that 180 days.
This question is from Facebook, Ashok Kumar Gobi. My priority date is current. I'm planning to travel on advance parole. What happens if the green card is issued while I'm out of the country? Can I travel back on the advance parole? Good question. Yes, there is a memo that says that even though technically speaking about your advance parole is not valid, they will allow you back on the advance parole. We have had many such situations, had no problem whatsoever at all, people coming back on advance parole after the GC is approved. That is only the first time when you go outside and the GC is approved. Now, once the GC is approved, you are in the country, and then you travel the second time though, that advance parole is definitely will not be valid. But when you're outside the country, your GC is approved, you will be allowed to come back on the advance parole. I'm assuming that you have the advance parole approval before you leave the country. That is absolutely needed, that you need to have advance parole before you leave the country.
Nitin from YouTube has an L1A expiring in October, also applied for the 485 in October of 2020, has the pending EAD and hasn't received that yet, and wants to know if his spouse can apply for an H-1B this year as a backup plan because the L2 EADs are such a mess right now. Yes, that is an option. Your spouse is eligible if they're maintaining L2 status through at least September 30th. If they get selected in the lottery, then they can file a change of status from L2 to H-1B that would take effect on October 1st. If the L2 is actually expiring before September 30th, then you'll have a gap, and that would be a difficult change of status to get approved.
Just some announcement. We've been receiving a lot of notices, especially for those people who filed the adjustment of status in October and November, that their fingerprints, their biometrics, they may use the old biometrics if that they have. doesn't mean that they are going to use the old biometrics if they never had it. Especially if the biometrics were been done within USA in the past 6 months or 1 year, they will use the old biometrics. Otherwise, they may not be. If you have done biometrics outside the country, at this point of time, we have no conclusive evidence saying that they're going to use the old biometrics that you have done outside the country. Question that came in is, for a lot of people, is that what's going on with the biometrics appointments for the people who filed their judgment of status in the month of October? We did receive some biometric notices. We haven't received for everybody. Is there anything that we can do to force them to do the biometrics? No, we can't. Biometrics are backlogged depending on the officer who's working on the file. It is backlogged from anywhere between 2 months to 10 months. Your biometrics have no impact whatsoever at all on your EAD and advanced parole application. They both go separately, and they can still be approved without biometrics. Also, a lot of people have questioned, is the I-140 approval needed for EAD and advanced parole? No, it's not needed.
M. Savale from YouTube wants to know, my daughter is turning 21 in May of this year. We have an I-539 that's pending since July of 2020 and still in process. I'm assuming this is a change of status to F1. And wants to know, how can she remain in status if we don't get that decision before she turns 21 in May? That's where the B2 bridge application is required to be filed. So that needs to be filed before she turns 21. You file that. You can file it online through USCIS's website, or you can file it on paper. But it's basically to bridge that distance from the time she turns 21 till the time the F1 change of status can actually be approved.
Questions from Praveen Kumar and Satyam. The 485 got rejected for silly reasons. What to do? And the prior date is not current. We strongly request that you refile the application right now and say, point out very clearly that they should not reject in the mailroom. There is a good chance they may take it. If not, you should consider the court litigation to force the USCIS to accept your 485 application.
Harshal from Facebook wants to know if an employee can continue working on the L2 EAD even after the L2 EAD expired if the green card EAD is still in process. Unfortunately, no. The switch from the L2 EAD to the green card EAD is not one of the situations that provides that automatic 180-day extension. So you'll have to stop working until you either get the L2 EAD approved or the GC EAD approved.
Shanaz has this question. With the EAD after 485 application, can I do more than one job? Do I need to stick with one employer? You can have more than one job. I don't see any problem in it. You're good. Do you need to file a 485J supplement to have a second job? No, you don't need to file a 485J supplement to have a second job. One job, one 485J supplement is enough for you. If you're not changing the main job, just adding another job, you're under no obligation to file a 485J supplement.
Snehal from YouTube wants to know, why are H4s filed back in July still not receiving biometrics, and those filed in October have already gotten biometrics? Well, I mean, this is government inefficiency at its best. You know, anytime there's a major backlog in applications, I've noticed over the years that as they're working through the backlog, they try to not make the backlog worse. So they will process later filed applications normally until they get through those earlier filed applications. So it's not necessarily fair, but it's not entirely uncommon in how the government tends to run these things.
Follow-up question by Ramesh from YouTube. Do you need to submit multiple 485J supplements if you're doing 2 jobs on EAD? You don't need to file multiple 485J supplements. You're under no obligation to do that. Ram Murthy from Facebook has this question. What are the chances for HR 1044 or Senate 386 bill to be bought back before April 1st? Well, what you mean to say is the removal of the per country quota limit. because Senate 386 and HR 1044 are dead right now, so new bill has to be introduced in the new Congress, and there is good chances. I'm pretty positive that a bill will be presented before April 1st, and that bill, I'm positive to have the provisions of taking the per country quota limit off. I'm pretty positive on that, and it should be done before April 1st. That is my expectation. Please keep watching on it. This administration has been only in power for less than 20 days. We have seen a significant changes, except today morning surprise that we saw online, which happens to be like February 9th full day, not April 1st, 9th full day. But otherwise, other than that foolish thing done by the USCIS to update it in wrongly, which doesn't, but as such, this administration has been taking very aggressive steps in a positive manner on the immigration. I've seen people of Democratic Party and Republican Party, both of the presidents, at least the last two presidents other than the Trump, has been very favorable on immigration. But they didn't act it in their first 2 years of them being in power. They tried to act on the last 2 years. But President Biden is not going to wait until the last 2 years of his 8-year period or whatever period that he can have it. He is poised to do it in the first year. And he has given immigration the top priority. I mean, the top priority, absolute priority. And nothing more priority can be given that I know of that what he's giving. So I'm pretty positive that this administration and we all can work together to get the discrimination off from the laws that exist right now.
Priya from YouTube wants to know, when can we hear anything about the H4 and H4 EAD premium processing rule that was passed by Congress quite a while ago? When will USCIS start implementing that? Yeah, it's been delayed. We've not seen any action really been taken on it at all. It does require the regulatory process. They have to decide how long the premium processing will take and what to set the filing fees at. USCIS claimed it was researching its capabilities and making sure that it has sufficient staffing and all of those excuses, but no action has actually been taken, and I have not seen any rumors or any kind of inclination that it'll be happening soon, so I don't think it'll help people in the near future.
Falguni has this question. My mom and green card holder has overstayed in India. What are the best way possible for her to come back? There is something called returning resident though. She has to make the application with the consulate. She has to request the waiver for her to being outside the country for more than 1 year. It may be good for you to consult a lawyer because there are a lot of plus and minuses. Is it worth even applying for the application? If your mother has been away, not just for this 1 year period and because of the COVID she couldn't come back, but she has been consistently doing that. Every time, every year she comes here, only stays for 1 week or 10 days and going back. It may not be worth for you to apply for the not re-entry permit, the returning resident though. If she has a clear record that she has been staying, paying income taxes regularly, she doesn't have to make income, but she has been filing the income taxes, then it's probably worth, if she just overstayed by a month or so, it's worth for her to apply the returning resident, get the permission for her to come into the United States.
Vishwanath from YouTube wants to know, his wife is having her H4 EAD card that's already valid till 2023, but it was applied for when he was working for Company A. He has since switched to Company B and is worried that that EAD card may not still be valid. So the EAD card does remain valid until it expires or USCIS revokes it, and there's no reason for them to revoke it here. So as long as you're maintaining H1 status, which means your wife is maintaining H4 status, that EAD remains valid till 2023.
Question, how long is it taking for the PERM approval? It's taking about 7 to 8 months nowadays to get the PERM approval. Emily has written a good article. If you want to go to rnlawgroup.com recently on if you are coming to the 6th year end, what should be your plans. Please read that article on rnlawgroup.com if you're coming very close. And please, guys, don't wait until the last 2 years to file for the green card application. Please try to plan around very early. Get your I-140 out of your way so that you can be in a safe position when you come to the 6th year. Question from Tumala. Does H4EAD claiming FMLA ability insurance for maternity be considered as a public charge? No, it is not considered as a public charge.
Kavitha from YouTube has an H4 visa stamp that's valid till 2023 and based on her spouse's approved H-1B, filing for the H4 EAD for the very first time and wants to know, do you also have to file an H4 extension or is it standalone? So in your case, because you already have the H4 visa stamp till 2023, I'm assuming when you entered the US using that visa, you also received an I-94 that's valid till 2023. That I-94 allows you to file a standalone EAD application. You do not have to file the I-539 along with it.
Srinath has this question. My wife is planning to go to India for more than 4 months and she's going to be on a leave of absence. Will it cause any problem in her H-1B? Yeah, that 4 months is a very long period of time for a H-1B to be absent. When she's trying to come back into the United States, the main question that pops up is that does she still have the same job? Was the job continuously there or was there an interruption in the job? So that's a very, that's not a situation I would like to have my spouse to be in when she's coming into the United States. Now, in another sense, if by any chance you are an H-1B and your wife is trying to go for 4 months, the better option may be that she goes and comes back on H4, and then if she wants to transfer back to H1, she can. Since she is already counted toward the H-1B number, when she transfers back from H4 to H1, she doesn't have to be counted towards the H-1B quota.
Arun from YouTube, his wife's employer is planning to file an H-1B for her this year. She's currently on H-4 EAD. He wants to know when the employer should file. Is the due date April 1st? If they wait till April 1st, you've missed the boat. So this is very important. It's a new process. Same process as last year, but it's no longer April 1st. The employer should already be working on having their My USCIS account, their electronic registration account, and they have to submit a registration on her behalf between March 9th and March 25th. If that is missed, she won't have any chance. Once that registration has been submitted, then the employer will find out around March 31st whether she's been selected. If she's selected, then the petition needs to be filed between April 1st and June 30th.
Emily, I need your opinion and discussion on 2 of the issues. So, we did stated that approximately about 100,000 green cards are going to be coming and falling into 2022, that is October of 2021. But at the same time, we made some announcement that approximately 400,000 applications have been filed, even though most of the 400,000 green cards that were filed in October seems to be Indians, and there's only up to maybe 100 and 150,000 green cards available to Indians. What do you think so of going forward in October 2021? Will there be a movement in the dates like the way what happened before?
Right.
Of course, please take it with a grain of salt. She is not accurate most of the times in predicting.
Nobody is accurate in that. So, all we can give you is our educated guess. Yeah, I'm very concerned. We don't know 100% exactly how many applications were received in the month of October, but it does appear that there were somewhere in the range of 400,000 applications. And if there's only 150 to 200,000 green cards available this year, there's going to be people who already filed who will not receive the green card in this year and have to wait until next year. So why would they move the dates even further forward if they have not already given out the green cards to everyone who applied this year? So I was very hopeful after this past October that the cases would be processed and we would be able to see the same kind of forward move at next October because of the family travel ban. But now I'm not so sure because there's too many people in the pipeline.
So this may be the kind of scenario where people have missed the boat, they missed the boat, Emily.
Yeah.
Same thing what happened in 2007, same thing what happened in 2012, same thing what happened in 2020. That's our guess. We hope we are wrong this time again, so we hope we're wrong. Emily, now another discussion though. We are expecting the bills now. Here is the comment that is coming out from Mano. Which bill is better? Which bill has the employment based? I know we are not prepared. They're asking us, is it Senator Durbin's bill or Senator Menendez's bill? According to my estimate, the Senator Menendez bill is going to be comprehensive immigration. According to my estimate, the Senator Durbin's bill is going to be piecemeal.
Yeah, I think Senator Durbin's is more focused on Dreamers, the DACA situation. There's another one coming up for TPS. So as far as I know, Senator Menendez's bill, which is Biden's bill, that's the one that's going to be comprehensive and is intended to include employment-based, intended to eliminate the 7% cap and figure out a way to use the unused green cards, maybe not count the dependents. So that one I think has the best chance of helping employment-based immigrants, but comprehensive is always tough to get past.
One thing is that Senator Durbin's bill is more or less what most people agree, what the Republican senators will agree and pass the bill with the 60 votes. That seems to be the way where, for example, for the DACA kids, most of the senators seems to be in agreement, though those kind of bills are expected to be coming from the desk of Senator Durbin from Illinois, but from Senator Menendez of New Jersey, it is going to be comprehensive. I wish that employment-based is a piecemeal. I wish that per country quota is a piecemeal, but it looks like it may be in the comprehensive legislation rather than actually being in the piecemeal, which is done by Senator Durbin.
Shimantaro Pear from YouTube has a STEM OPT that's expiring in June and is currently actually working 2 jobs using that, and wants to know if the H-1B gets applied this year, does that allow him to continue working for both jobs? So this is a question about the OPT cap gap. So the cap gap provision says that if your employer has filed a change of status from F1 to H1 for you before your STEM extension expires, your employment authorization, your STEM extension, is automatically extended, not for 180 days, but is extended through September 30th. And that does allow you to continue working for the jobs that you have. Yeah, so you don't have to have an H-1B from both companies in order to do that.
One question from Mahesh. YouTube has a question. He filed it and just want to state this. He received the EAD and AP receipt notices. Can he do the premium processing? No. EAD and AP notices doesn't have a premium processing option right now. The next question from Kumar from YouTube is that how long is it taking for EAD and advance parole to be approved? I've seen cases that have been approved in 1 month, but there is a chance that it may take up to 10 months for you to get an EAD and advance parole. Another question from the YouTube is, can I do the premium processing for the I-140 application which I already filed with the downgrade application? Yes, you can. However, we have had a significant amount of denials, even though we've been advocating to do premium processing for a long period of time. We have had significant denials on the premium processing. Please note, it's not the denial of the I-140, it's just the premium processing denials. Now, when we are getting the denials, the next day we are sending it back. There are some cases we are getting accepted, there are some cases that are getting rejected for the premium processing though. If the premium processing is rejected, you can refile it, and the problem is the statements of what they are making on the rejection seems to be ridiculously wrong. They are saying that, oh, you can't file an I-140 premium processing, you can't file an I-140 after 180 days after your labor certification has expired. Hey, dummy, I already filed an I-140, it's already there. So I wouldn't use the word when I refile it, but I'm just telling it to you guys. So it's definitely a uphill battle seems to be. Unlike previously, we're used to get the premium processing accepted very easily. It doesn't look to be as easy as I've been telling all along from past 3-4 months. I have advocated many times not to file in premium processing but convert it afterwards. It seems to be that it's an uphill battle, so I still recommend everybody to try it. The good thing about it is that your money is not lost. I mean, they won't take your money unless they convert it to premium processing. It's not that every case is getting rejected, only most of the cases are getting rejected, but some cases are getting accepted. You can refile it again. They tell you to, oh, you can refile it again. So there's nothing wrong in refiling the premium processing again. You're not paying 2 times the fees, so I would strongly recommend, even if you get the rejected, keep trying and keep refiling it.
Vikram from YouTube wants to know if we have any predictions for the number of H-1B registrations in this year's lottery. For me, it's a little too early for me to give a prediction. Last year was 275,000. What's interesting about this year is obviously we have COVID, which was not there last year. But at the same time, the job market in IT, unemployment is quite low, which usually means higher numbers of registrations. So, we have these kind of competing ideas where the overall economy might not be great, but with IT heavily using H-1Bs and that job market being very tight right now, we may see more registrations this year, unless employers are just sick of the whole thing after dealing with Trump for 4 years and not willing to file.
Look at the NASDAQ, the IT sector of the IT sector of the stock market. Man, it's rocking like a hell. I mean, what used to be $1 trillion company, really, we can't even imagine that. Looks like there are so many $1 trillion companies, and each and every $1 trillion company seems to be only IT companies. So thank you guys. I mean, you've been doing a very good job, and thanks for all the work that you have done. Let me go through some quick questions here. Vinod Kumar from YouTube has this question: can I file EB3 as well and keeping the EB2? My EB2 will be cancelled. If you file it as a new application, which normally all lawyers should be doing it, absolutely no problem. You can keep the EB2 and EB3 approval. We are suggesting the people that get PERM approval right now, apply for EB2 and EB3 at the same time. And you can keep both of those dates. You are not going to lose the previous dates at all. Rahil Abdul has this question: can I use my child's birthplace for the cross-country chargeability for the parents? Good question, but the answer is no. For those people who don't understand, of course, Rahil knows what a cross-country chargeability is, otherwise he wouldn't have put it. That if 2 people are there, wife and husband, if let's say the husband is the main applicant and the wife is born in Saudi Arabia, even if she is not a citizen of Saudi Arabia, if the husband is born in India and the wife is born in Saudi Arabia, even if the wife is not a Saudi Arabian citizen, if they both are married and the husband is the main applicant, you can file the adjustment of status based on the wife's country of birth. That is called cross-chargeability. Now, Rahil is asking, can he do the same thing if the kid is born in Saudi Arabia while he and his wife are born in India? The answer is no. Cross-country chargeability is only applicable for the spouse, not for the children.
A couple of questions from some people about working in the U.S. for a foreign company while you're not in a work authorized visa status. So for example, if you're waiting for your H4 extension, can you work for a company in India and be paid in Indian currency, or work for a Canadian company? The answer is no. When you're physically in the U.S., it doesn't matter where the company is located, it's where you're located. And if you're physically here, you're working here, that is not authorized if you're on an H4 or a B2 or something like that. So no, that cannot be done.
Amigo has this question that can a person who is living in the United States for 5 years on H-1B, can he apply for asylum? One thing is that Red Union PC is very deficient in the knowledge about asylum. So we are not good at all in the asylum. So I would request that you contact some other law firm. They are good at it. We are just not good at it at all. So we're not expertise in that. Question from Verma from Facebook is that my 485 EAD is pending. Can I still apply for the H4 EAD? Is it going to cancel the 485 EAD? No, it does not cancel the 485 EAD. You can have both EADs pending at the same time. Absolutely nothing wrong. And whichever EAD comes in, if you want to use it, you absolutely can use it, no problem with it.
Vinod from Facebook, his spouse's H4 visa is stamped, and she also received an H-1B petition approval, but has not gotten that stamped yet, and wants to know if she enters the U.S. on H4, can she look for a job using that approved petition? Unfortunately, no. Although she has the H-1B petition approved, if it was approved for consular processing, meaning not a change of status and there's no I-94 attached to it, she's not actually considered counted in the cap yet. The only way she's counted is if she gets the H-1B visa stamp or actually works in H-1B status. So to take advantage of that approved consular processing petition with a different employer, I'll say it's inconsistent, but usually it does not work.
Kishore has this question. Planning to go to India, he got his EAD and advance parole approval. Is it worth going for stamping or coming back an EAD and advance parole? As I said before, if your purpose is to make immigration lawyers rich and rich all the time, yes, try to maintain H-1Bs and advance parole. I'll plan on buying a Ferrari on your name. But if you don't like immigration lawyers like the way I am, I never liked immigration lawyers. I want to get rid of them as soon as possible from my life. And I don't want to make them rich. I'm fine with them driving these, little cars, but not Ferraris. If that's your motto, then I would definitely not use an advance parole in coming into the United States. Obviously, having said that, make sure that your I-140 is approved. You don't have any teenage kids that are born outside the country. Now that's me though. I'm not telling you what to do. I'm just telling what I would do if I were you.
Rajesh from YouTube, his wife is currently outside the U.S. and he wants to extend her H4 EAD. It's already expired, but her H4 is valid until December. Unfortunately for the H4 EAD, she has to be physically in the U.S. in H4 status in order to file the application. Once it's filed, she could then leave and wait until it gets approved before she's coming back, but she can't do it from outside the U.S.
Sunil Kumar has this question. Is it normal for the employer not to share the I-140 approval? I would say that it's not abnormal, I would say. 25% of the employers don't share the I-140 approval. But I have a solution for you. You can go to Google, search FOIA, USCIS, Freedom of Information Act, USCIS. You type in, you will get a form, you fill that form, you submit it with immigration, and you will get the complete petition, or not complete, but a good amount of petition of the I-140 that you need for any purposes. That is good enough for you for any purposes though. Now, how much does it cost for you to submit the Freedom of Information? $0. Do you need to mail it? No, you can do it online. How long does it take for you to fill this application? 10 to 15 minutes. Have you seen any problems in obtaining the Freedom of Information directly from the USCIS? None, zip. Does your employer come to know that you filed the Freedom of Information? No, he will not come to know that you filed the Freedom of Information unless you tell him.
Anik from Facebook wants to know, is it advisable to file a PERM now given high unemployment rates? So while we may have nationally high unemployment rates, higher than usual due to COVID, it really depends on the labor situation in the area of intended employment. So if you are working in a place where it's really hard to find the people that do your particular job and have your particular skill, even though there is a high unemployment rate, PERM is still possible. It's all about whether the employer can find a qualified, willing, and available U.S. worker in the work location for the specific job that they're sponsoring you for. So it really depends on the job and the location.
think so it's time, Emily, but we are posting some specific videos targeted to each topic though. If you guys want us to post anything particular, that a particular topic that you want to, recently we have posted on the age, kids who are going to age out, who are on non-immigrant visas, and also we have posted if you are in adjustment of status, if you want to move from one company to a different company. We have also posted on other issues with employees on a H-1B working for 2 companies, also downgrading of EB2 to EB3 way before the October quota came in. We posted those things. But if you would like to have any particular kind of things that you want us to address, please give us our opinion. Your feedback is very important for us. We do read the, especially once the, we do read the feedbacks that you give it. Please comment, let us know what exactly you want to. We will try to make those specific videos. Those are going to be like 10 minutes addressing only one topic. Please let us know which ones you want to. Anything else?
Thanks for joining.